disputes can be employee-employer, employee-employees, or there are various sources for disputes. How to redress these employee relations, how industrial disputes is not good for this industry's growth as well as nation. So because there is a 1947, the same year, Industrial Dispute Act also enacted. The third block talks about the Payment of Wages Act. So the fair wage, the employee can get a fair wage according to 1936 Act. Whatever they work, the working hours, he has a right to get a fair remuneration or fair wage as per this act. And also, as per government, say that they fixing this minimum wage act 1948. The reason is the whatever the market demand, like inflation rate or inflation rate, that has employee has a right to get a minimum wage as per this act. So that's the reason every 5 years, the state government, every 10 years, the central government has giving the PRCs, pay revision commissions, and they fixing the minimum age for this amount, so much this amount like this. So the 10th unit talks about the Payment of Bonus Act. So if the organization perform well, the contribution of employees also is a part for this whatever these profits. So they have a right the Payment of Bonus Act for establishments, like we have seen this every Dasra, the railways are declaring this bonus. At the same time, Singareni Colliery is also declaring the bonus. And some institutions also declare the bonus for employees for this. They contribute more. They have a right to get some amount also in the term of bonus as per this Act 1965. And Equal Remuneration Act also there, 1976, irrespective of establishments, irrespective of that. So they need to get equal remuneration. The act is 1976. We are going to discuss in detail and each act. Then the fourth block talks about Workmen Compensation Act. So this Compensation Act 1923 is required. So if the employee working in an organization like very health hazard organizations, or they can lose any their health issues, sometimes maybe they can lose their uh, what we call death, or sometimes can be partial injuries are there, or sometimes can be they can lose their body parts. So how the workmen can be compensated for this act has given the clearance, give the guidance how this compensation be provided as per this Act 1923. If the industry is very health hazard industry, or it may be very dangerous industry or chemical industry, so it will be the workman compensation also very most important to protect their family members and give these confidence their family members to providing the fair compensation as per this act. So like ESI Act is there, 1948, Employee State Insurance Act is there. Those establishment has mandatory to register under ESI, and they need to have a right to get the insurance at the same time medical treatment as per this Act 1948. Then the fourth unit talks about Employee Provident Fund and Miscellaneous Provisions Act 1952 and Payment of Gratuity Act 1972. These acts also talks about employee retirement benefits. He has served for either 20, 25, 30 years in organization. He feel organization is home. Then he has the right to get fair payment of gratuity at the same time provident fund. For the post-retirement period, he has to live in a good manner. Why? Because 50% of life he spent in organization has to get some gratitude as per this act. So Contract Labor Act 1970 and Maternity Benefit Act is also there, as woman has the right to get uh, benefit for take care the children's. As per this act, she will eligible for getting either 6 months for the period, or even fraternity is also there. The fraternity also, the 15 days will be provided for the two kids. For men and women also, 6 months for maternity leave. A benefit is there for take care of their kids. And these are the acts are there. And the last one is contemporary issues regarding Child Labor Provision Act 1976. Like India as a vast country, the huge population, still few families are encouraged to do the labor work because of their livelihood. But the government says that after under 14 years, no one is allowed to work. And one other side says that it's a mandate for free education, compulsory free and compulsory education for the children to spend their life, a childhood in the schools. It is it is a place to learn, and we'll see this country become a good economic condition and providing good sense for all these acts. Either 1986 Labor Act is there, and sexual harassment and women workplace. This act is in 2013 after Nirbhaya case, and after this so many incidents. So these workplaces are the wherever the workplace and employer employee can treat equal, and there is no deviation. There is no nothing. So like this act is this act is 2013. The Information Act, IT Act, is very popular. So previously, as the Factories Act, women are not allowed to work in the night times, and there is no, we can't hire and fire system as per previous acts. But this IT Act provide the new kind of environment for working organizations and providing new kind of jobs and outsourcing jobs and like that. Now, women has worked for even night hours. As per this act, there is a more flexibility is there because there is an the women are getting more and more opportunities, and at the same time, the precautions also there for industry side. So as a whole, there are 18 units in our syllabus, but all 18 units, what is the need for studying these labor laws, right? What is the need for anyone? What is the need for studying all this? What is the need for studying all this? Hmm? Why this much of acts are there in India? There are 18. There are more than 18 also there. Welfare of employees, only welfare of
20
employees.
26 laws.
26 laws. Why it is this much of laws?
Mm.
Hmm? Why this much of laws? What is
Run
the
the
need for
organization smoothly.
run the organization very smoothly, right? And then, as what's the need for as a management student need to understand the labor laws? The management student know the labor laws means you have to understand what are the legal provisions for this employer and employee. So their rights and duties we'll understand, and we give the same kind of respect, same kind of laws. We can't do the hire and fire system in India as we can see. You can see the other
Show no
nations.
discrimination.
Correct, exactly. So let's start with our discussion of our unit number one. So what our constitution says. So India is a independent 1947. Very next period now we have a constitution assembly, and we need to write in a constitution. We appointed so many committees. One is the draft committee, constitution draft committee, headed by the Dr. B.R. Ambedkar, the drafting committee chairman, and it took 2 years at 11 months and 18 days of time to write a constitution, and finally we are adopted constitution 26 November, and implement January 26 onwards, India is declared as a independence country. But at the same time, India is a very wide country, various kind of what we call cultures, various kind of geographical locations are there, different kind of languages are there, different lifestyles are there. So it's a entirely the heterogeneous kind of culture is there. But all together in putting in one place, but giving this priority. So our constitution says that as our constitution, India is a federal country, right? Means there are three types structure is there: local bodies and state or central. At the same time, the powers also given the central list, state list, and concurrent list. So like there are three kind of layer systems are there, three kind of bodies are there, right? So such a huge condition, and we are under the rule of 200 years from Britishers. We are scared for allow the private people to do the business, and till 1991 also, we are not encourage the private participation in business. But now the scenario is entirely different. So here they see this. The origin is American Revolution, 1886. Right, the basic is American Revolution and French Revolutions are giving the chance to we need kind of revolutions, to avoid such kind of revolutions. So we need to frame a labor laws to give the right to the employees as well as employer to treat equal, either in terms of working hours, in terms of monetary benefits, in terms of leave, in kind of identity or trade unions. So like The origin of this uh, revolution, these acts, the revolution of American Revolution, French Revolutions are the major source for this. So, as our Constitution said that many political thinkers have tried to define the term Constitution, let few of these, the Constitution always which citizens a component part, the state arranged the relationship with each other. So, like one and each other to maintain. So, so our constitution has some fundamental rights. Fundamental right has a land. At the same time, written or unwritten, some of these components are there. Their citizens have the rights. At the same time, some duties also there. So this the Indian constitution objective and certain futures. So it is not a general, but out of Indian constitution, we pick the topics related to our labor laws. As Pandit Jawaharlal Nehru has adopted the constitution and assembly, he spoke on 22nd January 1947. The principles outlined the resolution. The proclamation India has independent sovereign public. They establish a democratic union which equal to self-governance for all these constituent parties. He gave a statement at the same time, and we have a there are 16. See that no, there are 395 articles, 444 parts, 25 parts, and 12 schedules are there. And these silent futures talks about this. So many federal system is there. Fundamental rights are there. Fundamental duties, directive principles of states, secular state, independent judiciary, the people as a source of authority, like through voting rights. So there are so kind of futures are there. At the same time, our preamble, why preamble says about we the people of India having solemnly resolved to Constitution of India, justice and liberty, equal fraternity, unity and integrity, all our Constitution adopted. And 26th November 1949, we adopted this, and the secular republic also we added later 42nd amendment. The three words added secular, democratic, and republic in this our preamble. This is the first time we enacted this preamble, adding three words. Then there is a very case, and the Keshavananda Bharati case later part there. We can't amend any kind of changes in preamble, right? So nature of the state, sovereign, secular, democratic, republic. At the same time, the directive principles also there. The directive principles are very socialist and economic principles. Like the government has their give this economic equality for these people and providing whoever these people are suffering for, no, say that providing free houses and giving the equal livelihood condition. So distribution of resources and wealth among all the classes. Like whoever this good wealth, they need to collect the taxes. At the same time, they need to give this transfer for this amount in various ways to provide equal opportunity. And the men and women, they need to get same kind of uh, payment, equal work. The men and women paid equally for equal work. So there is no discrimination with the payment and work culture, work hour, everything is same for as per our directive principles. At the same time, the full employment. So no, nowadays there is a new topic like gig economy, right? Gig workers. There is no full employment, right? There is no gig economy. We talks about Zomato, Swiggy. There is no directive. No, these are act. These are act. Very few acts cannot be applied for these gig economies. So that is a debate. The central government or state governments also claim who is the owner of this, who is the owner of this gig economy. Zomato people, they can't claim that the boss is Zomato, right? So they can't claim that the whoever this the shop wala, they're not be claimed as the owners. So there is no owner for this gig economies. So this kind of new emerges are there. Maybe very few days we'll get a new act regarding this full employment and civilized work conditions, the good standard of living, and all these are required as per these directive principles, workers' participation, and Gandhian principles say that Article 40, 43, 47. So these are very self-governance, the village panchayat. and implement self-government, village panchayat use for they have the local powers, authority to allow the work as a unit. The cottage industries they work in rural areas, so there are sometimes cooperative societies also established, and ban of alcohol, drinking all these are talks about the Gandhian principles, Article 40, 43, and 47. So interstate principles also there. So international principles also. The India is, as I told earlier, India is a founder member for this ILO Labor Organization, Geneva. So to encourage the global harmony and security, to sustain good relationship between the nations, so respect international laws and agreements. Last few days we see this Trump visa prices are increased and restrictions working all these are there. So still India as a member they have a platform to talks about these various issues. The fundamental rights, so especially Bill of Rights, both are equal. The right of equality, right of freedom, articles either 14 to 18, 19, 20, 22, so 35, 36, the right to all these acts are talked about the rights of the rights, right to live, live and personal liberty as per this Article 21, and direct to principles as a fundamental right. As a citizens of India have a some rights as well as some duties to fulfill all these for this uh, our labor laws. The fundamental rights and labor laws of labor law legislations. So, like as our constitution talks about, but under Article 14, Indian Constitution is not possible to achieve absolutely equal amount of human beings as a real time to achieve the goal. So here it talks about equality before the law means that among equal the law should be equally administered, that like should be treated alike. So here the definition is given regarding the case, and Article 16 subsection 1 and subsection 2 Constitution frame Article 3 also they clearly giving the definition about this labor laws, and there are Supreme Court cases also there regarding these labor relations. What is the rule? All this. Then this first block talks about Indian Constitution, their labor laws, Indian Constitution, fundamental rights, direct to principles. What this is the source for this framing these labor laws. This is the base to frame the labor laws as our what our Constitution says. Out of which we frame the beautiful acts and to serve the nation. Right. The second is Indian labor legislation framework. So as per this Indian Constitution, we frame, as I told earlier, the so many acts are there: Payment of Wages Act, Minimum Wage Act, and Payment of Bonus Act, Equal Remuneration Act, 1976, and the like we have framed various acts, labor codes also there. So we are waiting for gig economy, gig related laws also. The scope of labor laws, like the labor laws, these labor laws, the industry, whatever this working industry are very dynamic in nature. So previously we see that industries are working and the products sell and buy. Nowadays it is integrated the global economies. So sometimes we import the product, the same we are what we call assemble, we are exporting the product, right? And see the our working environment is also differ. Why? Because the services also working hours also different. Earlier days, we work only the women's are work allowed for only mornings 7 o'clock to evening 6 o'clock, but now is allowed 24/7 as per this IT Acts. Why? Because these are working for this global organization. So their timings are different, our timings are different, their careers are different, our careers are different, their financially different, our financially are different. Like so, like various kind of that is the reason it's very complicated. At the same time, it gives opportunity to get more employment and see that labor laws also see these organizations how will be acted all this. Why the importance of labor laws? The employee right to protect. So employee rights has to protected. He has a life. He has responsibilities regarding the working hours, regarding the lunch hours, regarding the leave break, as well as good health working environments. So employee has a right for this laws as the constitution provided. as the acts also provided, right? At the same time, the employer has some duties also. So employer organizations need to clearly define the leave days, how many days are there, how many sick days are there, the HR manuals, right? We are government servant, we know every year our 21 days CL we can claim in a year. Like we can't claim 21 days in the January month. Can you claim January month 21 days CLs? Anyone please respond? 21 days can I claim in the first month of January?
No,
No, we can't claim, right?
no,
No, we can't. There is a rule is there in a year you can claim 21 days, but we can't claim 21 days at a stretch, right? We can take interval and take approval for higher authorities. So like the HR manual talks about the working manuals and salary hike, whatever this environment when we can claim all this. So there is the first one is employee rights are protected. This is the one object, the one importance for this labor laws. The second one is employee skills development, entry to the business. So, like employee has also participated for development activities. Like as a faculty, we participated various faculty development programs, attended workshops, seminars. We'll update ourselves regarding the skill development part. So, like as your employee, also your employer has to provide skill development program up to the market, up to the requirement of organizations, right? Why you need to update yourself to providing better performance. So that is the reason employee scale for development enters the business organizations. So as labor laws also say that to provide certain kind of skill development programs. At the same time, higher employee retention ratio. If higher employee retention ratio means the labor laws is employer cannot what we call remove the employees. So without reason, without any cause, they can't remove. So they need to follow some rules and regulations as per this retention. Higher employee retention is also required. If higher employee retention means it's good for the organization. If it is low, it is not good for the organization. At the same time, the labor laws and constitute to business success. So if the strong labor laws implemented, both management and as well as employees both are happy. So it gives a positive environment to contribute more and it gives a good kind of the success result. Like working conditions are good and advantage for the both rights. Employee become a brighter in their positions, like they become a promotion or become a better wage or better payment. So like the good labor relations are good in organization, it is better for these organizations. Like there are four important aspects for this labor laws. The very first one is right, employee rights are protected, employee skill development is required, higher labor retention ratio means we can't remove the employees as well as, right? So if the 10 people are joined, so finally only two people are no out. No, we need to retain our employees. We feel that the organization feel that these are their family members, right? So if there any problems are there, so employment the management has to help them and they will also own the organization. It's my organization. So I will ready to work 2 more hours. I more to work for this work also. Why? Because the organization give a life to me. So like this kind of attitude is required for these employees in the organizations. So these are the four important aspects for labor laws. So like India has a labor law policy. So based on the policy only we believe so many labor laws are there. Like the role of labor mostly come from the British colonial system. So India is ruled under 200 years of British colonial system. So we get some of these same uh, labor laws from these Britishers. See, the first British Parliament passed the Factories Act 1883. 1883 they passed British Parliament Act passed 1883, which deal the basic right 8 hours working hours. Still, see, we followed 8 hours working right. See the year where we are. Now we are 2025, but the act is see how the 8 hours working hours. British Factories Act 1883, which deal with the basic right like 8 hours work, child labor prohibition, and extra wage for extra work, what we call OT time, no? After then, the journey labor law started the various act passed Britishers, which such as Workman Compensation Act 1923, the Mines Act 2023, Labor Force Act 30, the Payment Act 1933. See how they think. Still, we followed 8 hours working hours. Still, we are not allowed for under 14 years of children to work, like as you know, extra hours, extra work for extra payment. All these are based in the year 1883. Still, we followed more than 150 years, right? Not more than almost 200 years, 150 plus years, it is there for these British rules. So when India got independence, India provides various rights to labor, which provide them equal or increase their social status. Today, our labor legislative councils are there. There are 44 are there. Now, after independence, we have these acts. After independence, we have this kind of acts. First one is the same year, 1947, Industrial Disputes Act, the Trade Union Act also we amended, the Minimum Wage Act, Factories Act, Equal Remuneration Act, Apprenticeship Act 1961. So all these acts after the independence and these acts before independence are there. But labor law policy comes from the part 4 of Indian Constitution under the directive principles of the state policy. So it is comes under our this policy. Okay. Then, so under our policy says that social justice, social equality, international uniformity is required. Means our laws are equal to labor international laws. Why? Because India is a very closely integrated to the global economies. That is the reason we followed the international laws also. The classification of labor laws. So labor laws are classified into as per this what we call layer system. As I told you previously, there is central list, the state list, and the concurrent list. So labor laws enacted by the central government for the respective enforcement with slow-lived central government means whatever these laws, the central government enacted laws are applicable this central funded institutions under the central government rules like railways is under central government rule and see that ONGC, CNGC, the PSUs, public undertakings, so their labor laws are applicable to the central government institutions. So labor laws enacted central government and some states also enacted, they will implement both state and central government. Some laws enacted for this state government enforced by the only state government. So whatever this, there are state list items are there. So these are applicable to state government laws. So laws elected through the various state government which apply the respective states. Because of the geographically the requirement, the state government they have own policy for kind of few some kind of industries are there, the specific industries, right? So the other classification done by the legislation brought under categories, laws dealing with industry relations, law dealing with remuneration payment, and whatever the previously we talks about, all the laws are classified in this way regarding remuneration, regarding relationship, regarding social security, regarding the nature and working conditions, working hours, and dealing with issue of gender equalities and women empowerment and socially will prohibition of such bonded labor and child labor, etc. So now laws dealing with employee training and employment. So like whatever the laws we talked about previously are classified into based on these categories. So this we can expect one question in this examination point of view. So the law classification. See these labor laws. So these are laws are central government has implemented by the only central government, that is fact ESI Act. At the same time, Employee Provident Fund Miscellaneous Act also it is under central government and Dock Workers Safety Health 1986 also. So all these acts under state government. And the second one is second both central government enacted enforced by these both central and state government. These acts are there. Third one is the state government, the enacted by the state government. These acts are there. So like there are so many acts are there. So it's applicable to the nature of industry, nature of working hours. So these all the acts you can't see in a IT industry. Can you find all the acts applicable to the IT industry? Anyone please respond? Can you tell these all acts applicable to the IT industry? The few acts will apply to the IT industry.
Yes, yes.
We can't say all right. So with these are the education industries, right? So it depends upon the nature of the business, nature of the industry. It is a private, it's a government, it is government or state government or central government or quasi government, or it is public under sector company, right? Is a PPP model. Now we talked about public relation partnership or BOT model. So like the nature of industry, nature of the geographical area, the acts is applicable. Right. So separate act for with the BD workers, BD cigarette workers, right? So like the Bonded Labor Act, so various acts for this purpose is very clear, right? Wherever the issue is there, then to address the issue, we have a new acts. Wherever the issue, see that the Private Security Agencies Act, Regulation 2005, based on this only, the private people are appointing their private securities as per this act. Earlier, we can't see this private security people, right? So whenever the issue came, to address the issue, there is a policy to frame the policy and at the same time to implement this policy. So we have a pause separate acts. So like the objectives of labor laws, what is the objective of labor laws? Yes, any doubts?
Sir, sir, as an update, I came to know that there are four labor codes
Yes,
newly.
yes, yes, yes.
I would like to know about those codes, sir.
I will tell you next class. Tomorrow I will update you that regarding four codes.
Right, sir.
Suitable for this management. So management seen that why this much of complicated, why can't we go for simplified this labor laws? So the plenty of list is there and we don't know which comes under, right? So all put together in only four codes, that codes will be address the issue. Maybe that agenda to favor the corporate industries. So they can run the business very smoothly and they always see that no, the employee cannot protect us. He can't approach any kind of higher authorities or legal, all this. I will update tomorrow morning. I will tell this what are the few codes, how it is different for this existing also. Okay.
Okay.
Then the objective of this wage loss, economic object, like if we get high payment, we'll pay return to the government, right? We can't deposit in American bank. Right? If I get a good salary, what I do is I will invest, I will buy a property, or I will buy a good shirt, I will increase my level living standards. So amount will circulate, right? So it leads to higher income. I can't deposit my salary account in US Bank, right? Can I deposit my amount in US Bank? Can I become America rich?
Mhm.
No. So it higher national income, it's part of higher income. And national income also spread over individual firm to nation and stable national income. That is the reason every 5 years we have a economic, PRCs are there, pay revision commissions are there. They revise these payments as per the economic objects. So employee will get uh, full company salary as per this market demands, market rates. The social objects, the social object is economic. This is called socio-economic object. Socio-economic objects mean the interrelations, the measure the inspired with social considerations. So wage policy must be addressed. So abolition of inequality, inadequate wages, the formation of impartial labor standards, all these are there. The socio-economic object. So labor relations related to wage. The first and foremost act is it is Industrial Labor Trade Union Act 1926. But regarding to wages, the first act is Payment of Wages Act. So if the employee work certain hours, the management has to pay their amounts. If they can't say that no, we won't pay. No. So as per this act, the employee has a right to get his the payment as he did some work. Right. It's a fundamental object act the guarantee to worker employee to acquire the wages due to without any unapproved reason, right? They can't stop the salaries, they can't stop their what we call wages without any reasons. So they have to tell, right? So that is the reason this act provides. So this act, it is an economy where the minimum wages are not paid. The labor should be secure to secure the wages, and this they can approach higher authority based on this act. So we are not get a salary, but this act says about, so if by working hours, though they need to pay the salaries. The second is, so the minimum wage as per the markets, as per this what we call consumer price index or wholesale price index, every 5 years or every 10 years, the government has giving this minimum wage for employees working various organizations. In both organized and unorganized, so they will fix. So based on they have a right to get this minimum wage salary. So if the government fix 18,000, the minimum wages must be 18,000 as per the rule, as per the government. The Minimum Wages Act is of 1948. To this act, the purpose is the employee will get the fair wage. Otherwise, they say that 18,000 salary, but they will pay only 12,000. It is under the Minimum Wage Act. Anyone can go and appeal the government, appeal the court, see that they are paying this much amount. It is deviating this, whatever the rules are regulated framed by the government. So, like they will have a right to ask the minimum wage as per this act. It's always enacted. Then scope for covering this act. So this act covers the various industries, and they also approached by the court, as I told it, when the Constitution Act challenged in 1955 the case of Vijay Cotton versus States of Ajmer before Supreme Court. The Supreme Court rejected the right. So like they have a fundamental right to uh, approach the courts to protect our rights. At the same time, Payment of Bonus Act 1965. So the bonus, the annual bonus is essential for component wages to workers. So this may be 8 to 10%. The total earnings of workers on the particular financial year. So as per payment, uh, this, as I told you, the Singareni railways and some state governments are giving this their own establishments for this bonus act, the bonus for 1965 act. So there's where the employees are more than 20%, where the employees persons are employed more than 20% in a financial year. So they are eligible for getting this bonus more than 20%, 20 employees. So appropriate government may be appropriate government, may be state government, sometimes local governments can be central government. So appropriate government define is given. It depending upon the where the industry is registered. Okay. So official gazettes also declared every time. So that cannot be applied these following cases employing in a life insurance protection. So wherever this is there is not applicable. Like the act shall not be applied to following cases. Employees employed here. So LIC is not applicable. Industries carried on or under authorized central government, state government, local authorities. The government employees are not eligible for getting this bonus. As we are government employees, we are not getting any kind of bonus. The Red Cross Society or any other institution like nature, including branches, the universities, other educational institutions, hospital, chamber of commerce, all these are not applicable for this bonus act. The others we use that, but apart from these establishments, others will get this bonus. Then Equal Remuneration Act 1976. So see that the difference between the Minimum Wage Act and the Equal Remuneration Act. Any difference is there? Both are the same. Wage Act at the same time Equal Remuneration Act. What is the difference between these two? Anyone? Equal Remuneration Act versus Minimum Wage Act.
Slight difference, sir.
It is depending upon this Equal Remuneration Act talks about the gender base. Discriminating based on the sex regarding the payment of wages has been onset of prevalent under unfair trade practices, not most of the countries in the world. Earlier there, but after this ILO, International Labour Organization, set up in Geneva, 1919, they treated both men and women same. So they have same kind of working hours, same kind of everything. The remuneration is also very equal remuneration for this, irrespective of gender. Right? This act talks about. So this act also covers under up to the payment of wages to person employees in a factory and to person used otherwise in the Factories Act, all is applicable for this Equal Remuneration Act. Now, the labor relations related to industries. The first and foremost is in the British period is Trade Union Act 1926 and Industrial Dispute Act 1929, Industrial Employment Act 1946, Industrial Disputes, Discipline and Misconduct and Domestic Inquiries given below. Like they are giving so many acts for industrial relations point of view. Right. Earlier, whatever we talked about remuneration point of view, like Minimum Wage Act and Equal Remuneration Act, all the acts related to wages. Now we move to wages to relations. The first and foremost is Trade Union Act 1926. So, like, still we have so many trade unions are there. So recently we see the newspapers like in what we call Vishaka Steels, Vishakhapatnam, the trade unions giving for call for a strike or burn that they giving the slogans regarding this. No, they have a right. Uh, there is a debate in what we call steel factory, Vishakhapatnam steel factory. See that the payment will be paid based on this outcome. How many? No, earlier is based the payment is paid on this number of hours. Now they change this based on the outputs. How many units you produce for the outcome. So third, there is a debate is going on regarding this uh, government as well as trade unions. So based on this, the Bombay Industrial Relations 1946, Maharashtra recognized trade unions and prevention of unfair trade practices 1971. So always there is a two different kind of approaches between the management as well as this employees, employer versus employee, right? So they say that we are working very hard. They say that we are paying a higher payment. Like there is a different kind of approaches between the employer and employee. Both are correct in their levels. Employee say that I'm working hard, but I'm getting a low payment, and say that I'm spending my whole total life and I don't get any benefits. I don't get any promotion, and I am not treated as a like he has own reasons for conflict. But at the same time, management also talks say that we are treated as their family, our family members. We paid in time salary, we give promotions. There is a two different kind of approaches, and sometimes there is a conflict will be taken place, but various regions. What is the basic reason? Anyone tell what is the basic reason to disputes, but between employer and employee? Basic reason in terms of monetary benefit, in terms of promotion, in time of working hours. Anyone?
Little clear question, sir.
Yes, ma. Yes, ma. What is the reason for industrial disputes? Is related to payment, related to working hours, related to promotion.
Payment and working.
Working hours and payments. Now the emergence of this Trade Union Act 1926. So this act talks about not trade unions. Every industry, if there's employees as more than 20, they have a right to form an union. They can register the union and they will sit together the management to discuss the issues, to address the issues, right? If they have a right to go for strike. At the same time, management also go for layoff. That is also there. The both side they have a rights are there. They have some duties are there. Both as per this Trade Union Act, we'll discuss elaborate in next sessions. Then the Industrial Disputes Act 1947. As I told you, the disputes between employer-employee, employee-employer, then the dispute can be settled through negotiation, conciliation, and voluntary arbitration, and adjudication also there to settle the issues. So this act, Industrialization Act, thus Bombay Industrial Act 1946 talks about the promotion of measure securing amity to good relation between employer and workmen. So related to promotion is a one. This investigate settlement of disputes, investigate and settlement of these disputes, like investigate nothing but the committee is appointed. Wherever the issues are there, first they will appoint a three-man committee or five-man committee. The committee are both side, as well as management side, as well as employee side, put together in a committee. So they will give it a time for 3 to 6 months, and the later part they will discuss both sides. So they will come together, conclude. If the both parties happy, the decision may be implemented, or they will go for other. So prevention of illegal strikes, and illegal lockouts. So strike is a weapon of labor, and lockout is a weapon of management, right? So prevention of illegal strikes as well as illegal lockouts. The relief to worker to matter layoff, retrenchment closet undertaking this all this. So promotion of collective bargaining. So like collective bargains are there, both parties sit together and discuss their issues, and they come from common conclusion. They come from the common conclusion for collective bargaining for this settlement of these issues. So this institution is not cover all the areas. So this act is applicable. Those industries have this applicable to employ more than one or more employees. So both technical non-technical institutions also working. The wages is 1600 rupees previously. Now it is always enacted. We can't see this kind of army, navy. Also, we can't see this kind of policies. Then the third one is Industrial Employment Act 1946. So here also this act, the standard order says that wherever the vacancy position are there, industrial employment, they need to come and publish a newspaper and ask the people to apply. Then he will select through conducting their own test, or they will conduct their own assessment to provide regular standing orders to workers of factories, the working relationship, right? So this act is applicable the employee establishment more than 100 employees. 100 or more workers as per this act, the Industrial Employment Act. So these also, railways. Previously, we have seen this so many. We bought an employment exchange book where we can find these employment notifications are given previously, right? So industrial discipline and misconduct. So this in the both side as an employer employee, if they go for misconduct, and discipline action will be taken against the both side. Domestic inquiry is also appointed. Domestic inquiry for what we call identify the issues and how to address the issue. So to conduct this domestic inquiry, there are six steps are there. Assurance to show cause notice. So show cause letter will be given first. Issue a show cause notice. They can ask for this respond. So all this has to follow to the remove any one employee, right? To re-employ this, they need to follow all these issues. Okay. Any doubts so far?
No.
I'm going speed, or is it okay?
Okay, sir.
Right. Now we move to the next part, regulatory provisions in relation to welfare, working conditions. Why? Because the working conditions are playing a very important role to contribute more and perform well, right? So working environment is also support to work and employee. At the same time, they need to safeguard their lives. When the workman is working in a health hazard industries, the environment is most important, and some kind of chemical gases, some kind of very health hazard, like we consume that pharma industries and other industries. The working environment is more important to safeguard ourselves at the same time to give a better outcome, right? So need the welfare of India. So we need a good kind of working environment is required as per Act also. So working on this, these are there. So like proper washrooms are required, and if the crutch rooms are required, restrooms, shuttle rooms are required, the canteens also proper canteens also required, and provide drinking water. It's a basic need, and arrangement of prevention of health condition. They need to maintain proper health safety, and at least they can maintain uh, good health conditions at the same environment, uniform and protecting clothing. So all these also required in a industries to maintain good working condition and environment. The industrial healthy and hygiene is also required. Why? Because some industries, as I told, some industries are very dangerous for health. So they need more safety. The safety measures are required. Like now, fire accident. We see the recently cigar industries in Patancheru. There is a more than 40 plus human life loss because of these health hazard, the industrial issues. The people lost their lives. They need to take the precautions. They need to implement the standard for this industrial health and hazards. So very rare we see that industry gas leak or something issues are there, but they need to take precautions for providing proper fire safety measures, health condition measures, and proper code of conduct they need to maintain. So all is required to industry has to follow to help life of these employees also. And health life they need to follow all kind of these measures related to employees. Occupational Safety Health Working Code 2020. So this is new. The recent government, the present government has given the Occupational Safety Health and Working Condition Code 2020. So this is Lok Sabha introduced Labor Minister, Federal Labor reintroducing the new changes happening this occupational code, all this. So this code to subsume 366 provisions under 13 major labor laws into one single code. As earlier one student asking for the why these four codes means they are put together in four umbrellas. Earlier these talks about regarding the health, safety, working hours, the 143 provisions, 13 major laws talk about same topic. So Factories Act talks about same, Mining Act same, Duck Workers same, all these 13 acts that talks about employee safety and security and all this. So all put together one common code, and it is applicable to all the workers where the employee working for at least 10 work. And all mines and docks are this code is applicable. Provision, especially special provisions for the certain types of establishment, and all these applicable this as per this code. The National Occupational Safety and Health Board is also established, one board national level. So this board has multiple committees, and they will discuss, they will implement these all the formalities. The penalty is also there if they are not implemented this code. The penalty is also implemented. So miscellaneous provisions of working conditions. What are the provisions are given for these working conditions to maintain proper hygienic and providing good health and good lighting? At the same time, if the woman is working, they need to provide special care, and crutch rooms are required. And all these are, just you can imagine this how this working condition in a Google company, how this Google providing working environment of employees, own employees. Just see how their working culture of Google company, their own policies, right? How employee friendly these policies for Google company, and notice for certain accidents if anything happen, so they need to provide information, they need to maintain alarm or something, the buzzard you have to come out. So like, and notice of creation of certain diseases if it is a chemical industry or some kind of gases are released or some kind of environment, then they need to provide this kind of notices any issue. Then recent amendment proposed in labor laws as Code on Wages 2019, Code of Social Security, SS Code is also 2020. Occupation, as earlier we talked about 2020. Industrial Relation Code 2020. These four codes are we are going to debate in discussion detail in tomorrow. How it is differ for this new. Therefore, labor law codes are there. Right? Means earlier there are multiple acts, the multiple is there. Now all put together, the simplification of four codes. The code related to wages, the code related to social security, the code related to working environment, the code related to relations. See, there are four codes. The fair wage, social security, and health relations. Like the four codes are there. Like overview of labor reforms are there. Reforms also labor reforms like economic environment changes. There are more amendments are required in labor laws and labor relationship also. That is the reason we have so many acts like trade union and simplification of updates. All these there. So Code of Wages Act 2019. So these codes and earlier we have a subsume all these codes. Previously we have a different kind of acts are there. Now these codes, these acts are merging this code, that is Payment of Wages Act 1936, Payment of Minimum Wage Act 1948, the Payment of Bonus Act 1965, the Equal Remuneration Act 1976. All are merged in Code of Wage Act 2019. Right? Why? Because all these acts are talks about the wages of employees. Right? So that is the reason to avoid the duplication, multiple provisions to create a common code of related to wages. At the same time, the highlights of this code, it defines what is mean of wage. It defines the between the workers and employees, and they define what is equal remuneration. It what are changes are required in respect of minimum wage. They remove the threshold limit of trigger application the payment of wages. So earlier there is a threshold limit is there for the employees. Now there is no threshold limit. The definition of contractor and contract labor. So previously, before 2000, we can't see the contract labor and contractor. Why? Because previously all the work done by the government or public sector undertakings. But later parts, the private people entered in the business. So to customize this working culture and the appointed contract employees and the contract labor, and they also define. Earlier, there is no provision. This code is defined this what is contractor, who is the contract labor, and regarding their employment, regarding their payment, all we can see this labor laws, contract labor laws. Provision of related to period of payment wages, the payment of bonus, all we covered in this code. I will stop here and tomorrow we'll continue. Any doubts so far?
No, sir. Sir, it would be little helpful for us if you can provide the last year question papers, sir.
Okay, I will
Model
try to
question.
get, yes, I will try to get this previous year question paper.
Sure, sir, because that will be helping us to understand the importance of which chapter and what to be precisely studied.
Okay, sure. I will update.
Thank you, sir.
Any other doubts?
No, sir, as of now, all clear.
Any others like Pawan, Kalyani, Mathur?
No,
Sir,
sir.
another
Yes, sir.
question.
Yes.
సో ఇప్పుడు మనకి అసైన్మెంట్స్ ఇస్తారు కదా అసైన్మెంట్స్ లో ఇచ్చిన ఏమైనా క్వశ్చన్స్ ఇంపార్టెంట్ అని చెప్పి మనం చదువుకోవచ్చా ఎగ్జామ్ కి లేదంటే ఎవ్రీథింగ్ అహెడ్ ఇస్ ఇంపార్టెంట్
No. Will tell you the important topics. No problem. Okay.
ఓకే సార్ థ్యాంక్ యూ
Okay. Why?
బికాస్
Because this is
18 చాప్టర్స్ అంటే
yes,
మళ్ళా
18 units is a very big syllabus.
కరెక్ట్
Okay. Uh, okay.
ఓకే సార్
I will try to share the previous year question paper. I will ask them to send me.
ఓకే ఓకే సార్
Okay. Yes, someone is try to speak. Hello. Okay, I'm leaving the group.
ఓకే సార్ థ్యాంక్ యూ
Okay.